Well, grandparents today often find themselves in court seeking a court-ordered relationship with their grandchildren. The question arises whether a grandparent can actually be required to pay child support. Here with the answer, plus answers to your questions, is Live at 5's family law attorney, Sonya Coffman. So can grandparents actually be forced to pay child support?
No. The court can only order a parent to pay child support.
That's a good thing. So grandparents totally out of the equation when it comes to paying child support.
Now, if a grandparent is appointed managing conservator of the child and they're actually raising the child, they may be providing direct support for the child's needs. But court-ordered child support, only parents.
Okay. Now we've got lots of questions, so we're going to jump right on in here. What is Texas law on getting parental rights terminated? My daughter's father is not involved in her life at all for 3 years now and doesn't pay his court-ordered child support.
There is a statute that sets out a number of bases on which a parent's rights could be involuntarily terminated. One of those is failure to support within the parent's means for a year. So that's certainly something that this viewer could look at. But there's also the issue of a voluntary termination of parental rights. So possibly this father would sign a voluntary relinquishment of his rights, but generally the courts are going to be reluctant to do that unless there's someone stepping up to adopt.
Okay. And that's something that you would have to go through a lawyer or the Attorney General's office? How would you go about doing that?
Generally through an attorney, because you need to look at the various bases and file the pleading for that and then put on proof of the reasons why this person's rights should be involuntarily terminated.
So it's going to take a process. It's not going to happen overnight.
No, it's not just a form.
Yeah. Okay. How can I get my child support transferred from California to Texas? I live in Texas and I've been living in Texas, but they're charging me more than Texas law would.
So this man is paying child support and he's paying it under California law even though he lives in Texas. He should contact the Attorney General's office, but generally I think that they are going to apply the child support law according to the most recent order, which sounds like it's a California order, and that he's going to have to get a modification filed in Texas if that's what he'd like to do.
Okay. After a divorce, which parent makes the decision on a minor child's religion?
It's a great question. We see a lot of conflict with that. Generally, a divorce decree is going to say that whichever parent has possession of the child directs the child's religious training during their possession. So you can see that could be a huge problem if a child spends one weekend with one parent, another weekend with the other parent, and maybe two conflicting religious trainings.
If it's 50-50, then they could go back and forth.
It could be. And you would hope that these parents could sit down and talk about it. But if not, then you may have to go to court for a modification and prove on best interest what's going to work best for the child.
All right, Sonya, as always, we appreciate you stopping by. Unfortunately, we're out of time. But if you'd like to have Sonya answer your questions, you can always mail us at the address listed on your screen, fax us 892-7305, email us at laf@kftm.com, or you can post those questions on our KFTM News Facebook page.